down and ready to ride.
Oh, I do like that song. It will become in my repertoire. Sorry I'm late, guys. Sorry, not sorry. Sorry, but not sorry. I think it is gonna be stick with it, William. And guess what? I even made an outro today. It's special. I made it just for you guys. But it also plays the song. I think it's a good one. And it is copyright free. Woo! Gotta love that. Sorry, I'm literally rolling a joint. Hi, Dale. Thanks, reseller. Oh, is Chris Engelby here? Because Chris tried to brighten my day today, and he bought me this lovely necklace off of my Amazon wish list. How pretty is it? How pretty is it? Hi, Lizette. So we're going to have to say thank you, a big thank you to Chris. I think this is a birthday gift that came early, so thank you. Isn't it gorgeous? I'm so happy. Love it, love it, love it. What a day we've had today. Doesn't it feel like it's been about 4 days in one? Jonathan Miller's here. Good, glad to hear it. Fuck. It's as if, well, my phone knows when I'm live, and they still choose to email me at this moment in time. Sorry, hold on. I forgot to close something. There we go. Look at me disappearing into this green screen. Anyways, fruit roll-ups. I gotta get a new P.O. box. I had a P.O. box for a while, then I moved, and now I should try and get a new P.O. box. I live with a very scary guy, so part of me is like, oh, I could just tell people my address, but I know that's not smart, so I won't do that. But, yeah. I know, isn't it great, Vicky? It's so pretty. I'll show it up close in a minute after I finish rolling this joint and I get us going on some court. No, I'm not gonna put my address out there, Courtney. I'm gonna get a P.O. box. I was actually just looking at sending a packet. Oh, for fuck's sakes. No, it didn't work. I was just thinking about sending a package to, I'm too high profile. I wish. Sending a package to Estados Unidos, the United States. And it was pricey in some senses, but also like how is it going to take 10 days for it to get to the United States? That doesn't make any sense to me. What are you taking on, Eskimo, like sled or something? But no one's swimming out to the island. Yeah, you're right. Nobody will come out this far to get me. Okay. Joint is rolled. Drink is almost done. I'm drinking my energy drink today. We have some Judge Bromlick to watch, and then we also have some Webster. Oh, geez. I was like, what was it? Judge Webster. Fuck, I forgot to do that. Okay, well, whatever. It has to go through border inspection. Yeah, I guess so. Yeah, I have to like fill out a harmonized sales number for it and stuff like that. A little bit confusing, but I used to do controlled goods at one of my jobs, so, and like harmonized sales numbers, HST numbers and stuff like that. So, so we're going to start out with Bromlick, Judge Bromlick. I haven't watched these yet, so I'm not sure about them, but we will see together. Jesus Christ. Almost opened up the wrong one. Okay, let's go with this one. At Peace Arch. Oh, at the Peace Bridge. Oh, Buffalo. That's on the other side of the country. That's definitely my weed tray that I just spilled.
So here's the lineups.
Ugh.
You want to speak to me, please? So Steph is this one. Okay. Josh. Okay. Steph. Okay.
Thank you.
Teresa.
I like this.
Josh. Stephanie. Okay. Josh. Patrice.
Oh, that I understand now what you mean, Teresa.
Oh, we're gonna have one coming in.
Oh, what's going on?
Dwayne Wilkerson coming in and then.
Oh, I have that one.
You do have that one?
The file, I have to go get it.
Oh, okay.
I mean, I have that file.
Leave the exam on and,
Yeah, he just got. It starts with 2002. I'm just gonna give you the, base, okay?
We don't have. This, oh yeah, everybody's here. Okay.
Oh,
Judge.
I'm not gonna get the file on this one, because, it starts at 2002.
Okay.
Okay,
Print out.
you got it.
You guys, I'm really regretting that I only have one energy drink. Not enough energy. Whoa, sir, your glasses. Every drop counts. What is going on in this court? Woo! Just having one of those days.
Okay.
All right.
County session, page 1, Nicole Smith versus Jameson Cloud.
For the record, this matter is before the court for purpose of reviewing the defendant father's parenting time. This hearing is being conducted via Zoom. Present is Attorney John DQ representing the plaintiff's mother, Nicole Smith. Ms. Smith is present. In addition, Attorney Ron Bruce is present representing the defendant father, Jamison Claude. Mr. Claude appears to be present. Good morning, everyone.
Good morning, Judge.
Morning, Judge.
Morning.
The last order entered by this court in January of this year directed the defendant father to complete the intake with family counseling shelter services. And that supervised the parenting time would continue with that agency.
Oh, you can't say it.
Hopefully we've made some progress in that regard. The parties have conferred with Mr. Pratt this morning. Mr. Pratt recommended that the current order can remain in effect. And that either party may request review date after father's release from incarceration. Is Mr. Claude currently incarcerated, Mr. Bruce?
No, Judge, he has an April 13 sentencing date. He's looking at some period of incarceration. He had an outstanding OW I-3, I believe.
What type of sentence is anticipated? Local jail sentence, prison sentence?
Possible prison, Judge.
Okay. Right. Has he completed the intake with family county shelter services? Have they started any supervised parenting time?
Judge, he has been experiencing time with the family member. I believe it's his aunt. She has been out of town the last couple of weeks, so he hasn't had any parenting time for the last, I believe, 2 or 3 weeks. But he has not been able to complete the intake. At this point, I don't think they're recommending that take place because there's a 6-week lag, and in 6 weeks, my client will have been sentenced. So
It is.
I guess what my client's requesting, Judge, is that the court possibly consider his aunt being allowed to supervise them on an additional day, Saturday and Sunday for 2 hours as opposed to the 1 day. He is looking at some serious incarceration. He would like to maximize his time with the child. My understanding, child's having some behavioral issues. Hopefully Dad can assist with that prior to this incarceration.
The court does note that the order was entered back in November of 2023, which should provide for parenting time for Dad at the home of Linda White, I believe on Saturdays. For 2 hours of a period. Mr. DQ, what about that? Obviously, if your client, his mom, comfortable that Ms. White will not permit any alcohol use in the presence of when the dad is visiting with the child?
I don't believe my client has any issue with her being a supervisor. The problem that's presented itself is we know that this incarceration is probably going to be prison time. Mr. Claude hasn't done any of the stuff to move forward and try and facilitate more parenting time. That family counseling shelter services intake stuff, that's been on the table for many, many months, and he's done nothing to make that happen. He hasn't provided us or anybody with any counseling or other therapeutic notes or indicators that he's been getting any type of rehabilitation, therapy or treatment. So I think if the presently community mental health has an assessor, I believe, at Ms. Smith's house presently. It appears that the child is having some severe problems with ADHD. And part of that problem has been...
Tell me about it, buddy. She laugh cries as she hits play.
Some acting out because of the visits with Dad. The visits, I believe, have gone pretty well, according to Ms. Smith. So I would ask you to just maintain the status quo. And when he gets done with his sentence, we can come back and revisit this. Hopefully that will have him sober. He will have gotten some treatment while he's in wherever he's at. And we can approach this from a more therapeutic position.
Okay, Ms. Smith appears to have someone in the room with her. She's making motions to someone. Ms. Smith, we're in court right now. Who's in your room?
Community mental health.
Okay, I just want to make sure the child's not in your room. Well,
No, just like Mr. DQ said.
Well, obviously, completing the intake, yes, all that would do is get Mr. Clott on the waiting list, but there's a long waiting list of a couple months, Mr. DQ. So the court would like to explore some additional time with Linda White. And again, this court can't dictate Linda White's schedule. Again, obviously, if Dad's going to be incarcerated for a time, he should have be able to have some contact with his daughter or the child. I'm not sure if it's a daughter or son. I don't recall offhand. Before he is incarcerated. So right now, is Miss White generally available on Saturdays?
Currently in Florida, Judge, but hopefully she's coming back in the near future.
I'm sorry, Miss Bruce, I didn't catch that. She's out of town.
Miss White's currently been on vacation. I believe she's in Florida. I think she should be coming back though. So when she comes back, we're asking that time be Saturday and Sunday.
And who would communicate this to Miss White? Would it be Mr. Clott or Miss Smith?
It would need to be Miss Smith.
Aunt, but I'm not sure if she's an aunt and on which side of the family.
She's on Mr. Clott's side of the family, and she would need to make the contact because there's not supposed to be any contact between Mr. Clott and Miss Smith.
Okay, all right. So Mr. Clott would be able to reach out directly to Linda White, then, correct?
Yes.
Do you see him look up at her? I'm going to go back like 5 seconds. Watch when the guy says they're not supposed to have any contact with each other. and then watch him look up at her screen. It's funny. Right there. Oh yeah, watch.
All right, so Mr. Cloud would be able to reach out directly to Linda White then, correct?
Yes.
Okay, and it's just a matter of then Miss White informing Miss Smith when she's available,
Correct.
right? So. So currently, I believe the last order was sort of based by the parent time on Saturdays after counseling. Supervisor Linda White's house is Montreal still engaged in counseling sessions on Saturday mornings.
They are changing to Wednesdays this week.
Okay, well, let's set up a time on Saturdays and Sundays. Maybe so a couple of hours in each day. Mr. DQ, is that unreasonable?
Hey, Ron.
I'd defer to Ms. Smith on that, Your Honor. I'm not sure what the schedules look like, and I'm not exactly sure where the therapy has gone with the young man through this process.
Could we just do a longer time on Saturday? That way
Okay.
she doesn't have to have me there both days, so she can have time to herself on weekends.
Right. Yes, that's not unreasonable, Mr. Clyde, but I'm gonna have you talk with Mr. Pratt again, but Mr. Clyde, bite your tongue. I'm informed that
Yes,
you
ma'am.
are
Yes, sir.
not acting appropriately, and the court will not tolerate that. Do you understand that?
Yes, sir.
Okay, Ms. Pratt, you might take another 10 minutes with the parties to see what we can work out on some Saturdays. Mr. Clyde suggesting maybe a little long time on Saturdays, maybe 4 hours on a Saturday or something over the lunch hour. Maybe you can have lunch with the child. We're talking basically just another month or so till Mr. Clyde is incarcerated. The court believes he should have spent some time with his daughter, as long as it's not creating issues for his daughter. Of course, we don't have Miss White to talk with right now, but obviously if Miss White is not willing to be involved in that, then the court can't control that. But if you could just talk with parties again for maybe another 5 minutes, please.
Yes, sir.
Thank you.
What? They're gonna talk for 5 more minutes? I don't understand. Wait, how long is this? I think it's 11, 12. 12. Okay.
Have time
Okay,
to
sorry.
herself
I'm just
on weekends.
trying to find the next one for us. Might be this one, and it might be the next one. We'll see.
Patience is a virtue.
We had snow here today. It sucked. Scott, what the fuck is your angle, dude? Is the phone on the floor?
But Judge Reed was right.
Court is now in session, bottom of page 1. Ashley Cooks versus Scott Combs.
For the record, this matter is before the court for the purpose of reviewing DNA test results. This hearing is being conducted via Zoom.
Whoa, it's a Maury. It's Maury, you guys. We'll find out if he is the father. If so, he will be required to move his camera up so that we have a proper angle for him. Why does it bother me so much? I don't know, but it fucking does. Hi, Tin Man. How are you? I'm amped up. Apparently the energy drink is kicking in. Oh, for fuck's sake.
President of Attorney Barry Savage, representing the defendant, Scott Corns. Mr. Corns appears to be present. Is Ashley Coons present on audio?
Yes.
All right, good morning, Ms. Coons. Good morning, Mr. Savage.
Good morning.
The court just received from Ms. LaPrade a copy of a DNA test report from DNAcenter.com, dated February 29th, 2024, which indicates a significant probability of paternity on the part of Mr. Corns relative to the minor child Isabella Kuntz, 99.9999% probability of paternity.
You are the father,
Kuntz, have
right?
you received a copy of this DNA test report?
Stephanie did email it to me because I didn't get it, and then she ended up emailing it to me. I'm still trying to bring it up, and it's just loading, so it might take a minute until I'm off the phone, and it might bring it through then, hopefully.
Okay, I want you to review this report and advise the court whether or not you have any objection to the court entertaining this report to determine paternity on the part of Mr. Corns. Mr. Savage, obviously you are requesting that the court adopt the results of this DNA test report. Is that correct? And determine Mr. Corns to be the biological father of the minor child, Isabella?
Yes, Your Honor.
Okay, we'll wait for Ms. Kuntz to review that report. I was hoping everyone would have received this before today so we can timely address this issue, which was set for 9:30, now being almost 10:20. Is there a 10 o'clock minute ready?
They're in with Patrice.
Okay.
All it's
Your
doing
Honor,
on
it's
my
my
end
understanding.
is,
Ms. Kuntz,
yes.
did you receive a copy of the report?
It is just loading. That's all it keeps doing is loading for me. I backed out of it, went back into it.
Your Honor, it's my understanding though that Ms. Kuntz was not questioning the paternity. I believe it was just Mr. Corns. So in our discussion, she was not questioning the paternity.
Thank you. Is that correct, Ms. Kuntz?
Correct.
Okay. I'm just indicating for the record that this DNA test report does indicate, and this is pretty standard, a significant probability of paternity, 99.99999%. It certainly verifies that to this court. It's a business record, subject to admission, and it certainly indicates to this court that Scott Corns II is in fact the biological father of Isabella. And even though you don't see that in front of you, are you willing to acknowledge that Mr. Corns is in fact the biological father of this child?
Absolutely.
All right, Ms. Kuntz and Ms. Corns, can you both please raise your right hand to be sworn? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Yes.
All right, Ms. Kuntz, could you please state your
Yes.
name and current address for the record, please?
Ashley Kuntz, 2365 West Temperance Road, Temperance, Michigan, 48182.
Sir, we have an address for you of 2365 West Temperance Road. Have you changed your address?
No, 2365 West Temperance.
I'm sorry, so we got the correct address. Right, Ms. Kuntz. Do you specifically admit and acknowledge that Scott Corns II is in fact the biological father of your daughter Isabella?
Yes.
Do you have any questions for the court?
No.
Okay, Mr. Savage, do you have any questions of Ms. Kuntz?
No, I do not, Your Honor.
All right, Mr. Savage, if you can do a voir dire, Mr. Corns, please.
Scott, you've seen the DNA report,
I have.
and you satisfied that you determines that you are the father of Isabella, the daughter to which Ashley Kuntz gave birth.
I do.
And you make the statement under oath.
Yep.
All right, thank you, Mr. Savage.
Chris is here. Chris, I was saying it's so lovely already. I'm so happy with it. I don't know why this thing is so delayed. I'm going to play the thank you sound. Thank you, thank you, thank you. Thank you, thank you, thank you. Thank you, thank you, thank you. Where is he at? There it is. Yay. Seriously, thank you so much. Oh, look. It's so pretty. I love it. Thank you, thank you, thank you. I'll do it again. Yay. Okay.
Based upon the testimony, based upon the DNA test report that's the court is in receipt of, as well as the testimony of the parties, the court finds and determines that Scott Corns II, the defendant in this matter, is in fact the biological father of the minor child Isabella Kuntz. The parties have before with Mr. Pratt, who's part of the court's fine recommendation.
Pardon?
Mr. Pratt has provided the court's fine recommendation that the parties shall share joint legal custody of the minor child with physical custody to the plaintiff mother. What that means, Ms. Kuntz, is that two of you share equal in a major decision concerning the welfare of Isabella. Let's say Isabella needs an elective surgery. You must inform and consult the father for things like that, of that nature. Major decision concerning her welfare, health, education, religion. You understand that? With physical custody being awarded to you, so you make the day-to-day decisions.
Yeah.
Further, it's recommended that the issue of child support be referred to the front of the court for a formal investigation recommendation, with each side having 21 days in which to object to any recommendation, or the start date for that child support should be March 1st, 2024. Further, that the party shall mediate with Mr. Joshua Walker on March 28th, 2024 at 1:30 p.m. via Zoom regarding parenting time. That is a recommendation. Ms. Kuntz, do you understand the recommendation of Mr. Pratt this morning?
Yes.
Do you have any objection to the court adopting this recommendation?
No.
Okay. Mr. Savage, does Mr. Corns have any objection to the court adopting?
There was a teacher when I went to school named Mr. Savage, and he was pretty cool. Not savage, but cool. Thank you. This is one of my favorite dresses in my collection. It is, yeah, I love it. I love it. I love gray. Baby. Let's get through this one, and then I'm going to tell you guys, I have Judge Webster. I just remembered that I didn't do the redactions that I planned on doing today because I got distracted. So we'll do live redactions where I'll just come on the screen and cover it up because the dude's social's on there, which is not acceptable.
This recommendation?
No.
Okay. All right, the court will adopt the recommendation, finds it to be appropriate and best as minor child. Obviously, Ms. Coons, Mr. Corns is entitled to parenting time to develop a relationship with this 4-year-old daughter. It's important for your daughter's welfare to have a relationship with her father. I understand there is a long distance. Mr. Corns lives in Marquette, Michigan. Is that correct, Mr. Savage?
He lives out in the Upper Peninsula in Keweenaw.
Obviously, that makes things challenging.
Yes.
For personal contact. I don't know if Mr. Corns maybe has relatives down him in this side of the state that he can come down during the summer months. But in any event, that can be discussed with Mr. Walker on March 28th at 1:30.
Mr. Corns' parents, which would then be the grandparents, Isabella, also live near Mr. Corns in the Upper Peninsula. So,
okay, well, it's pretty hard to send a 4-year-old up there.
Pardon?
It's pretty difficult to send a 4-year-old up there who doesn't have any relationship with her dad to send up with strangers. I think Mr. Corns needs to make some arrangements to come down here to have some initial contact with his child, so the child knows who her father is.
Yeah, and I think there has to be initial contact. I agree. And then
I think it needs to go very slow, and they need to meet slowly.
Are you talking about Mr. Dursley? You talking about Mr. Dursley? I wouldn't call him adoptive parent, adoptive dad, but you know. Also, I just wanted to show you guys this, my pin again. This says on here, don't hate me because I'm a little cooler. And obviously it's a little cooler. Is that grand? I love it. Seriously. But I did, in fact, make myself bleed by putting that pin on there. So, you know, you win some, you lose some, I guess. Got a cool pin, made myself bleed. Jonathan, that's cool. I'm looking for some things to read out loud for like a reading exercise for on the channel that are out of copyright. Out of copyright. You know how it is.
Or it goes as far as like her going to spend like a weekend up there or any time overnight with him. I think they need to get to know each other before the overnight start.
I agree.
Just so she gets comfortable and he's comfortable as well.
All right, I agree. Everyone appears to agree with that, Ms. Kuntz, but hopefully Mr. Corns can make arrangements to come down this area.
I can.
Rather than driving the child up 5 hours, but a 5-hour drive in any event. The court will adopt the recommendation. The two of you maybe can make some progress with Mr. Walker and start at least slowly. And obviously, and then we can always review child support, you know, in a few months from now or 6 months from now, but let's maybe get something started where Mr. Corns can have some contact and meet Isabella. All right, anything further this morning, Mr. Savage?
Nothing further. I think we meet with the facilitator on the 28th at 1:30. And I think that will be important. And then I think we'll also have the issue of child support will have to be resolved. So,
okay.
I think the friend of the court plays a role in that. If I'm wrong,
That's correct. I don't know if they have the recommendation ready by March 28th or not.
By when?
Mr. Walker can assist with that during mediation.
Okay. Okay. All right. If there's nothing further, that will conclude this matter. The court will adopt the recommendation. Copy mailed out to everyone. Thank you, Mr. Savage. Have a good day, everyone. Thank you, Mr. Brad.
Thank you, Your Honor.
Thank you, Your Honor. What the fuck? Trying to learn what it is that bogs Streamlabs down. Still learning it. Hi, Erica. How's it going? Okay, so we are now going to watch I'm just trying to think of how to do this. Okay, so these are like internal problems that you guys don't really need to care about. But one part of this video is in 2x speed. So I might try and slow that down and play it, but it seems laggy when I just share my screen as opposed to like sharing the video. So I'm going to start with that. And then we'll go from there. Yeah. It's a minute. So it's really like 2 minutes. 2 minutes of, no, so 4 minutes. 4 minutes of this. Okay, so give me one second. Also, I do want to point out, this is Judge Webster from Texas. Dana's here. And I want to point out that he seems a lot nicer to this girl than he is to Miss Simone. I'm going to say that. Okay, so now I need to come over here. I need to go to white. Share screen. Share screen. Oh my God. It's not like this. Hi, Christy. Sorry. Okay. Okay, so just before we get started on this, I'm going to point out that it might be a little bit laggy. It's just 2 minutes or 4 minutes, and then we'll be on to the better quality one that's at regular speed. So bear with me.
All right, y'all, this court's on the call number 39970. This is in the District Court of Jasper County, Texas, and it's in the interest of Ty and Kylie Meredith. Miss Nicole Meredith.
Also, that is as loud as I can get it. I don't know why it's so quiet on that one. I apologize. I'll boost the volume as much as I can, but I don't know if I can anymore. I'm sorry. I'll double check and make sure. Yeah, it's at 100. I apologize. Oh, Paisley, you're so fucking stupid.
If I need you to raise your right hand to tell me that your hand is in the air.
Yes, sir.
Miss Meredith, do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You put your hand down. Mr. Thad Meredith, I need you to raise your right hand to tell me that your hand is in the air.
In the air, and I swear.
Mr. Meredith, do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you put your hand down. Miss Cannon, does the state have any other witnesses besides the parties?
No, Your Honor.
All right, this appears to be a motion to modify to adjust the child support in this case filed in January.
Yes, Your Honor.
All right, in case it's been called, we'll call you first witness.
Thank you, Your Honor. I am going to call Miss Meredith first. Miss Meredith, you understand why we were here today, correct?
Yes, ma'am.
Okay. My first question for you is, are the children in this case currently on health insurance?
Yes, ma'am.
Who carries that health insurance?
I do.
Is that through your employer?
Yes, ma'am.
Do you know how much it costs to carry health insurance just for the children's portion?
Yes, ma'am. It's $493.21 a month.
And does that include the dental insurance as well?
Yes, ma'am.
You don't have a separate breakdown between health insurance and dental insurance?
No, ma'am.
Okay. And the $493.21, that is just for the two children who are on this case, correct?
Yes, ma'am.
Okay. Your Honor, I am going to pass the witness.
Okay, call you next week.
And I will call Mr. Meredith. Mr. Meredith, you understand that we were here on a motion for modification, correct?
Yes, ma'am.
And are you currently employed?
Yes, ma'am.
Who do you work for?
Dragon Products.
Your Honor, the state would ask to introduce as an exhibit a copy of the W-2 form from 2023 and the current paycheck and the paycheck stubs that Mr. Meredith has provided.
That wasn't provided to me, Ms. King.
Okay, I can I share my screen? And it looks like based on the first paycheck stub that we've received that.
Ma'am, sorry. So that is the live redaction that we're doing right now. So she has his fucking W-2s up there. I guess that's your what is that? I don't know. Stop sharing that screen. Okay. So no, KCC frame better. I should be better now. I will continue to play this. I'm not going to put it up on the screen at all because I don't know where the social security number is, but it needs to be not on there. So we'll just listen with me sitting here over top until they take it off the screen. Judge mentions it, by the way.
That Mr. Meredith would have began working for Dragon in September of 2023, based on the earning statements that are presented. We have several paycheck stubs that he has provided that go through not every paycheck stub, but they go through February of 2020. And the state is asking to introduce those as exhibits in the case.
So what are you asking to introduce? The W-2s, the
W-2 as exhibit A and the paycheck stubs collectively as exhibit B.
All right. Mr. Meredith, do you have any?
Sorry, I was muted. Thank you so much, Chris. Gifting memberships. I hope somebody got it. I can't see. Let me go ahead and hit the thank you thing. Oh my God. I have to actually spend tonight emptying the computer, you guys. Oh, that's loud. Thank you again, Chris. Seriously, thank you so much. Also, hi, Hunter. Hope you are well. So like I said, there is court underneath me, but it has somebody's personal data on it. And so I am protecting them with my body.
Any objection to me looking at the paycheck stubs?
No, sir.
Do you, Mr. Meredith, do you have any objection to me looking at the W-2?
No, sir.
Miss Meredith, do you have any objection to me looking at the paycheck stubs?
No, sir.
No, sir.
Miss Meredith, do you have any objection to me looking at the W-2?
No, sir.
All right, they're gonna be viewed in camera. I'm not admitting them into the evidence. It looks like there's social security numbers on those. You can
Okay.
stop the share screen.
So, Mr. Meredith, it looks like since your divorce decree.
Thank goodness, finally, Judge. Calling it like it is. So that was like 5 minutes or more that his social security number is just out there. I appreciate you all sticking with me as I was exactly what we needed today, the kind of meat shield we all need. Again, I apologize about the audio. I figured out why it is so quiet now. I've just figured that out, but I can't do anything about it except to say I hope it won't happen in the future. But it's as good as we got. Hi, Beverly.
It was done that you've changed employers. Is that correct?
Yes, ma'am.
And with the change in employment, has your income decreased?
By half.
Okay. And since you've started working for Dragon, how much are you making per hour?
$17 an hour.
And you do get some overtime.
Hey, Dragon. Does anybody get that reference? I just laughed so hard when they said he was working for the Dragon or Dragon. But does anybody get that? I'll give you a hint. It's from a Robert Munch book. I wish those were, I could read out loud. No, it is from The Paper Bag Princess. And when Robert Munch reads that book out loud and he talks about the princess, she like tried to tire him out. And when she was trying to see if he was still awake or not, she would lift up his ear and yell in it, "Hey, Dragon!" And then when I would read it to my daughter, I would do it like he did. And I would get louder and louder and louder each time you did it. Hey, Dragon!
Is that correct?
Very seldom.
Okay. Looking at your paycheck stubs, it looks like if I go in to, it looks like there were some weeks where you did not get overtime. It looks like there were some weeks, beginning with your November 11th, beginning with the paycheck stub that begins 11/11/2023 and ends on 11/24/2023. Looks like you had 16 hours of overtime then. The next paycheck from 12/9 to 12/29, it looks like you had 5 hours. The paycheck stub from January to, the next paycheck from December to January, another 16 hours. And then the following one, there was no overtime. The last one that you provided, which has a pay date of 2/9/2024, indicated like 4.55 hours of overtime. So when I had calculated support, I had estimated that on average you were probably only doing around 3 hours of overtime per month, averaged out over the time period. Would you agree that on average you're doing about 3 hours per week of overtime?
Yes.
Okay. And on do you have any other children besides these children?
Yes, I have one that's 26 years old. He's
Okay.
grown.
Okay, but you don't have any other minor children that are living in the household with you that are your biological children or that you pay support for, do you?
No, ma'am.
Do you have access to private health insurance or private dental insurance for the children at a reasonable rate to you?
No,
So you're
Nicole takes care of that. That's why I'm paying insurance.
okay. Well, you understand. And as far as your employer, as far as your employer goes, you don't know what it would cost you to carry the children on your health insurance through your employer, do you?
No, ma'am, I don't have a clue.
Okay. What type of work do you do?
I'm a welder.
And with the job with Dragon, is this expected to be a permanent job?
Yes, ma'am.
Okay.
Isn't that a pretty low hourly for a welder? Is that what he said he was? He's a welder. I thought that they got pretty decent money.
Because you understand that sometimes people in the construction related industries, they may work some shutdowns and then they're laid off, but that's not the case here. This is expected to be your permanent job, correct?
Yes, ma'am. I work in the fab shop.
Okay. I will pass a witness, Your Honor.
Do you have any additional witnesses?
Your Honor, I do not have any additional witnesses.
What's the state asking for in this case?
Your Honor, in this case, based on, again, the evidence that was provided, and both parties' agreement that Ms. Meredith is actually the one who's providing health insurance through her employer, we would ask that she continue to provide the health insurance. We calculated, Judge, Your Honor, I apologize. I need to reopen the evidence and introduce the pay record in the case. Neither of the parties were objecting to the judgments, but I need to introduce the pay record.
Okay, well, you just ask them.
Okay. Ms. Meredith, as far as the arrears that are owed in this case, I think we had agreed that the arrears were $6,597.41 as of February 29th, 2024. And we were asking that Mr. Meredith pay $100 per month towards that. Is that correct?
Yes, ma'am. That was the option.
Okay.
Yes.
And Mr. Meredith, you didn't have any objections to that, did you?
No, ma'am.
As far as the medical support judgment, he was in arrears $5,366.62 as of the 29th day of February 2024, and he was going to pay $75 per month towards that beginning the first day of April 2024. Is that correct, Ms. Meredith?
Yes, ma'am.
And Mr. Meredith, again, you had no objections to that. Is that correct?
I just want to ask one question. That $5,000 you're talking about, that my half?
That is based off of the order, the previous order where you were ordered to pay current medical support. That is not unreimbursed medical expenses.
I'm supposed to pay half of what insurance don't.
No, sir. Mr. Meredith, you're supposed to pay the premiums. You owe Miss Meredith for child support and you owe her for the health insurance premiums every month on the children.
Yes, sir.
Go ahead, Ms.
And Your Honor, with Miss Meredith providing the health insurance, unfortunately, the cost of her health insurance exceeds the 9%, or even the 10.5%. For health and dental insurance. So we were
Okay, but logistically speaking, you cannot tell me that was not worse in terms of like skippage when I had the ticker at the bottom. Sorry, I think it's my computer, but again, I'm getting frustrated. I'm frustrated. Let's hurry this up, lady. She's taking so long, and the look Judge Webster has on his face. Ugh. It's like the look I have on my face right now, too. Hold on. Sort of.
asking that she go ahead and keep the children on the health insurance based on the statutory guidelines. The 9% would be $295 per month. That's assuming three hours a week of overtime, which seems to be supported by the record or the evidence that was provided. It would be no step down provision because, again, she is paying for both children the same amount, no matter how many children were on the order. The dental insurance, she said it's not a separate cost, so she would carry the dental insurance as zero. And then the current child support would be $625 per month with a step down provision to $500 based upon those guidelines, assuming that the court agrees with the three hours per week of overtime.
So the state's asking me to reduce Mr. Meredith's child support to $625 a month.
Yes, Your Honor, based on the guidelines and the medical support to $295.
Okay. So that's what you believe the evidence that you've submitted showed to me.
I believe so, Your Honor.
All right. Mr.
And
Meredith.
to confirm the arrears.
Right. Mr. Meredith, you've been at Dragon for 3 months, 4 months?
Been there longer than that.
Oh, you were there, were you there all in 2023?
No, sir.
Okay. So when the child support was set in your final divorce decree just a couple years ago, it was set a lot higher. Where were you working then?
I was working for Olmsted.
Okay.
In Louisiana.
Okay. And I can assume based on this divorce decree that you were making a lot more money back then.
Yes, sir. A bunch of money.
Well, what happened to that job?
I failed a drug test, breath alcohol.
Oh, I see. Okay. Miss Cannon, you showed me the W-2 from 2023, but I didn't actually see it. What was the gross income for 2023 on that W-2?
Where I had just showed you, Judge, the
No, for fuck's sakes. Okay, so now I have to remove that and then go to the last part of the video. And I'm going to have to do some quick work here again. 110. Okay, here we go. I'm going to pull myself up.
steps. It would look like he started that job in September of 2023.
Did you have another W-2 from a different employer?
We do have a different W-2 from a different.
Oh, this is also like we're catching up for about 15 seconds, so I didn't want to miss the ending, but I'm not going to change the speed, so just deal with it.
Employer, Your Honor, which I can also introduce. Hold on just one second.
No, don't introduce.
I want to introduce it.
We put enough of Mr. Meredith's demographic information on the internet.
It looks, yeah. It looks like there is another, actually, I don't have another W-2 from 2023. I only have one from 2022 for Olmsted.
Yeah.
And the one from 2022 for Olmsted was $43,414.58.
Wow. Mr. Meredith, how long have you been working for Dragon?
I don't know. I started around March or so.
Okay. So you've been there
March,
you've been there for about a year.
Yes, sir. Almost about a year.
Okay. All right. Thank you, Mr. Meredith.
Thank you.
All right, Ms. Meredith, I can assume by the answer that you filed that you don't believe that Mr. Meredith's child support should be adjusted. Is that correct?
That's correct.
All right, why don't you think that the child support should be adjusted? And before you answer that, I need you to understand, Ms. Meredith, that the state of Texas is just a pure sum state. You know, whatever Mr. Meredith makes, that's what his child support is supposed to be based on. So why do you think it shouldn't be based on his income?
Because he's perfectly capable of working the job that he was working before to make that money for the child support from what it was based on when we divorced.
Okay. And if he were to go back to that type of job where he was making that kind of money, do you think that the state would be just as fast as filing another lawsuit to increase his child support as they were in this case?
I guess, yes, sir.
Okay. So, I mean, and I know what you're saying, and I don't disagree with you, Ms. Meredith, but this lawsuit that was filed by the state was filed on January the 19th of 2024. That's less than 2 months ago. We are already in court adjusting child support on a lawsuit that was filed less than 60 days ago. That's pretty fast.
Yes, sir.
If the state were to determine that Mr. Meredith was making more money, they'd probably give him a couple months to make sure that he was actually making that money, just like they did in this case. And then once they did, they'd probably turn around and file another lawsuit to get it back in front of me, where I set it back to where it was before based on his new income.
Right, but he does not want to do that. Like, he's told multiple people he's taken a lower job to get his child support.
Okay, now we're at the meat of it here. And so she's alleging that he's taken a lower job just to get out of paying child support. And what Judge Webster said, what Judge Webster says here is actually good advice.
Lowered.
Okay, but in all actuality, Miss Meredith, the state is only taking about a quarter of his income for child support. So he's losing at least another quarter of his income that he could be making if he was making more money, right?
Right.
So he's hurting everybody, including himself.
Right.
That's just pride. But it doesn't.
That's just pride. I love how he says pride. That's not how we say it in Canada. We would say pride. Your pride. But the judge is right.
Change the math. The math stays the same. If he's willing to work a job for a lot less money than what he's capable of, and the bottom line is he's basically just hurting himself. Because he's losing more money than the kids are. Right?
Yes, sir.
Now, I'm not saying that's what Mr. Meredith is doing. I'm just showing you the example so you can show that if pride is playing an influence, I don't have any control over pride, Miss Meredith.
Yes, sir.
All I have control over is math. Doesn't that sound strange? But it is just math, Miss Meredith. That's all it is. And actually, you're probably not going to see a big decrease in the number of the actual money that you're receiving, Miss Meredith, because he still owes you a large chunk of money for the arrears on this case. So that has to keep flowing in anyway, all right?
Yes, sir.
Ms. Meredith, you got any questions about this case before I make a ruling?
I mean, yes, sir. In the divorce decree, it was stated that he was supposed to pay all of the insurance, and what she's coming back with was the $295
Right.
for the medical insurance, not
There's a limit, Miss Meredith, as far as what I can order him to pay.
Yeah, Jonathan, this is interesting. And I think in Texas they can impute income as well. But I think that I think what I just imagine that like the judge is pretty savvy on that. So I just think he'd have done it if he could. I don't know that like failing a drug test is a pretty like understandable reason for an employer to let you go. And it doesn't necessarily mean that it's willful underemployment. You know what I mean? Especially if he's working full time at the same type of job again, just getting paid less. It's unfortunate, but I understand it. Oh, for God's sake. Oh, no.
It's above the limit, which is 9%. I can't order an obligor parent to pay more than 9% of their gross income for health insurance. And that's so $295 is 9%. That's as high as I can go. That's by law. That's what the state legislature set it at. And so the oath I gave says I got to set it based on their statute, my statute, our statute.
Yes, sir.
Good question, though. It didn't used to be that way. It used to be I could set it whatever I wanted to because you have health insurance. But they went in and blocked that. They said, no, we really meant you, Judge, to not go above 9%. So I can't go above 9% anymore. Any other questions, Ms. Meredith?
That's it.
All right. Mr. Meredith, you got any questions about this case before I make a ruling?
No, sir.
The court's going to find the court has jurisdiction. The court's going to find based on the testimony of the parties. I'm going to take judicial notice of my own file. Include and take control of the controlling of support order. I think I'm required to do that by.
He's doing the lawyer's work here, by the way, because they always say, Judge, could you take judicial note of the court file, please? And that allows him to reference the previous order, but she didn't ask him to do that. And so he's doing it sua sponte from the bench is what that means, I think. I might be wrong on that.
Statute. I'm going to find that there has been a material substantial change of circumstance since the divorce decree in 2022. I'm going to adjust the child support that Mr. Meredith is paying to Miss Meredith, the amount of $625 per month. He will also pay an additional $295 a month in cash medical to Miss Meredith, and since she's going to continue to be ordered to carry the health insurance and dental insurance on the children. As per Miss Cannon's request, I'll set dental support at 0. We'll put it all into the medical. It'll actually make it a little cleaner in the order. I will confirm the arrears in this case and say that as of February 29th, 2024. Mr. Meredith is behind in his child support, the amount of $6,597.41. His medical support, the amount of $5,366.62. Mr. Meredith's going to pay the child support judgment back by paying $100 a month. And the medical support is $75 a month. All changes in the child support will be effective March the 1st of 2024. Arrears payments will also be effective March the 1st of 2024. Court costs in this case will be due by Mr. Meredith, and I'll make those due September the 30th of 2024. Ms. Cannon, did the state hear all the terms and conditions of my court order?
Yes, Your Honor.
All right. Mr. Meredith, Miss Meredith, what's going to happen now is Miss Cannon's office is going to send me a court order. If it matches what I said here today, I'm going to sign it, get it back to them. Then they're going to make a copy of it and send it to each of you, okay?
Yes, sir.
Yes, sir.
Mr. Meredith, you got any questions?
No, sir.
Miss Meredith, do you have any questions?
No, sir.
All right, I appreciate y'all's patience today. I appreciate you all being here on this Zoom hearing with me. You'll get a copy of this after I sign it, and you're both free to go.
Thank fucking Christ I can pull that off. And it will stop lagging. I apologize, guys. I really do have to clean my computer out tonight. It's not a joke anymore. It has to be done. So that new amount did include his new adjustment. It included the arrearage and medical arrearage. What I do have a question about Jonathan Miller is, without fail, Judge Webster always assigns court costs to the men or the fathers in these cases. Do you know if there's if there's some sort of, is that a Texas thing? Is that a standard thing? Like, he always gives them 6 months to pay. It's very interesting because on the first of the month, he does this little transition where instead of saying like August, he said September. And so he does this little, giggle about it. But he always makes the guys pay the court costs. And he does this joke where when people say, well, what are the court costs? Occasionally, he'll say, oh, I don't know. I used to know, but now I do so many different jurisdictions, and there are so many different fees that I couldn't keep track of it, and it changes all the time. The court clerk will get that information to you. I couldn't keep track of it, Mr. So-and-so. But, the fees are assigned because they couldn't make an agreed order and not go to court because they couldn't. Because some of these are not necessarily not agreed orders. These are just OAG files that have been brought forth. Often, in this case, it was different. These children weren't on Medicaid. So that's a weird one in a way. Generally in Texas, at least, and for most places, when you are, now I've forgotten. Whatever. I can't remember. My brain's just not working. I'm reading, I'm trying to do this, I'm trying to do that, I'm listening to my neighbors, I'm being nosy. Yeah, and it's something that he does in every single hearing. And actually, I don't think, is gay marriage legal in Texas? I don't know. But, or civil unions or whatever, or is that legal everywhere in America? I'm not really sure. My point is, would we see a divorce in or like a custody case in front of a Texas judge that's same-sex couple. We have. Paisley, remember? Oh yeah. Here I'm talking to myself. We did that one case. Oh, that might have been on the old channel. It all runs together now. You know, if I add up in the last year, how many episodes or streams I did on this channel and the old channel, I think we're almost at 500 or maybe more than 500, which I think is pretty insane for a year. Anyways, I hope you guys have, oh, I made a new outro to play at the end. So I'm very proud of that. So please just enjoy that. I think Colin's going live. I'm not going to redirect because my computer can't handle that. I know Mikey did it today successfully twice. Bravo. But I hope you guys have a wonderful, wonderful, wonderful evening. I am going to say my bye-byes now, and I am going to, oh, this is interesting though. Yeah, because he was saying how the state's just going to know within a few months. I guess they would know because of state tax, but that seems odd to that they would connect them together, you know? Anyways, Jonathan Miller, as always, thank you for being here. Thank you everybody for being here. I appreciate each and every one of you. I'm going to play this outro. I'll say it first, then I'll play it, and then we'll be done. Remember that I love you. I'm proud of you, and I will see you in the next video. Bye. Thank you, Chris. As always, you're so sweet. I love it. I'll play the outro one more time. Thank you again. Bye.